We'll move on to our second discussion, which is about legal rights. Um, with us today is Shane Flannery from CJ Law. Main inquiry we hear from carers around legal matters is around power of attorney. So I'd like to ask Shane to introduce himself. Thank you.
Thanks, Lisa. So my name's Shane Flannery. I'm a solicitor. I've been a solicitor for 30 years, and I always make the old joke, yes, I don't look like it, do I? But I am that old. And lasting powers of attorney have been a large part of my practice. Now, lasting powers of attorney are very powerful documents. They are documents which are designed to allow you as the donor of the power, and they're referred to as the donor within the documents. You can, as the donor of a power, appoint people, your attorneys, to be able to make decisions for you if you ever lost capacity. That is, if you lost the ability to make decisions yourself. There are two types of lasting power of attorney. They are two separate documents. One is to do with financial decisions, and one is to do with health and welfare decisions. They're independent of each other, but both, I think, are extremely useful documents. So the donor has to be over 18 in order to be able to make lasting powers of attorney, and indeed those they appoint have to be over 18 as well. But other than that, there's a great and wide discretion. You can appoint anybody that you want. And you can appoint as many people as you want as your attorneys. What I would say is, though, if you get too many people, you've got to make sure that everybody you appoint broadly has the same view and would come to the same decisions. What you don't want is everybody having different decisions on anything that they're going to do on your behalf, because, of course, if you have falling out amongst those that you appoint, then we're not going to get forward at all, and maybe no decision can be made at that point. So you can appoint as many as you want, you can appoint anybody you want, but you might have an idea or have a think about who are the best people for whatever roles. Now, the application process is, the document itself is a paper document. However, you can go online. You can either order a blank copy of the documents for you to fill in together with the guidance to assist you to do so. You can order them from the Office of the Public Guardian, and no doubt we can make details of the website available within the chat. So the Office of the Public Guardian, and you get, you can order, as I say, the blank copies of those documents sent through to you. You complete them, populate them, sign them, and return them together with a fee. The alternate way that you can do it is that you can ask, or you can go through a process online and be asked a number of questions about, your full details, who you're appointing as attorney, their full names, addresses, etc., etc. And this will populate the document online, and then you can have that populated document sent to you. So a lot of the hard work has been done already, and there's guidance through that process as you go along. So the documents, when they come out to you, whatever way you have them done, they will need signatures upon them. But of course, the first signature that goes upon it is that of the donor, the person who is appointing the attorneys. But the donor has to have capacity at the time that they are making those documents, that they are signing those documents. And the person who would say, yes, they have got capacity, can either be a professional, or it can be somebody who has known that person for more than 2 years. So a neighbor, a work colleague, a former colleague. If they've known somebody for more than 2 years, then they can certify that the person who's making these lasting power of attorneys, the donor of the power, has the capacity to be able to do so. So the entire process doesn't have to involve lawyers, doesn't have to involve anybody save for you and this online process of obtaining the documents itself. As I said before, they are extremely powerful documents. So of those two sorts, as I said before, we've got the one that deals with finances. Well, that kind of does what it says on the tin. If somebody loses capacity, an attorney can then take over running their bank account, can make payments on their behalf. They can invest on their behalf. They can sell things on their behalf and take those funds in. up to and including selling a house or, the biggest things that you own, your attorneys have the power to be able to do this. Of course, the overarching point of this is that your attorneys must always act in your best interest, and as part of the process, when they sign up to this, they declare that they will do so. And there are various principles that they have to adhere to when acting on your behalf. So the financial one, as I say, does what it says on the tin. I think the just as important one, however, is that of the health and welfare, health and care decisions. That has, again, a very powerful document, but that has that can assist you if you want to or need to make decisions for things such as, well, what's happening to somebody as far as their treatment is concerned. If the person who's made the lasting power of attorney cannot make decisions themselves and the doctors are looking to somebody to make those decisions, the only way that you can be involved in making decisions on behalf of that person is if you have been formally appointed under a lasting power of attorney. Now, this point was made, so I was lucky enough to be able to go along to a set of medics, general practitioners, who are having a conference about exactly this point, and this is their perspective. One of the GPs said, relatives of patients often believe that they have an absolute right to make decisions about the care of their relatives. This is a misconception. It's not true. It can cause difficulties for professionals who are making decisions about such things as end-of-life care, especially when the relatives have conflicting opinions about what is the best thing to do for the patient. A health and welfare lasting power of attorney would make some decisions easier for the care staff as well as for the patient and their family. So that's the perspective of the GPs. That's the perspective of those who are treating physicians. And they very much want you to have this document in place, but they warn that if you don't have this document in place, unfortunately, whilst you might presume that you can be involved in their care or treatment, unfortunately, you cannot. So those are the two types of documents. In order to be able to get them and use them, having gone through the process of their creation, you have to send them to the Office of the Public Guardian with potentially with a fee. It's £92 for each one to be registered. However, as Michael, I'm sure, will confirm to you, if you are on certain passported benefits or if you're on a low income, then you can get dispensation and you won't have to pay either all of or half of that fee. Michael, would you jump in and just confirm, please, what those passported benefits are?
Yes, of course. So you don't have to pay anything, so you can get an exemption if the donor is in receipt of income-based benefits such as universal credit, housing benefit, council tax support, income-based ESA, or pension credit, with the exception that it's only guaranteed credit.
Thank you very much. And I think also if you're on a low income, you can then, is it less than £12,000?
Yeah, if you have a gross annual income of less than £12,000, you can't get the full exemption, but you can get 50% off the fee.
I'm grateful. Thank you very much, Michael. So that's a whirlwind tour of the two types of lasting power of attorney, extremely powerful documents. You really should have them in place. And of course, what I say to everybody in these sorts of circumstances is we start off thinking about our cared for individuals, but of course, the very carers themselves need to think about putting these in place for them and who might look after them, who might make decisions on their behalf should they lose capacity in the future. So that's as much as I've got to say on the topic for the moment. Lisa, do you have any questions for me? Or Eve, are there any questions coming through?
I was just going to ask, you said it cost £92 for the power of attorney.
Yes.
Is this if you do it with a solicitor or if you do it yourself, or is that a different?
That's the fee. So I'm encouraging people to do it themselves. Of course,
Do
if
it
you want to go
themselves?
and see a nice solicitor and pay for that, then I'm presuming that those nice solicitors would probably have their own costs to assist you in doing so. But the fee for registration is that £92. And as I say, all the documentation is available online, and there's very good assistance. The support information, the FAQs and things like that, very beautifully done, written in plain English, and they can explain quite difficult topics relatively simply. So it's well worth doing yourself. But of course, if you want to use a solicitor, we will, of course, do it for you.
Brilliant. Thank you. Is there any questions on that in the chat, Eve?
Um, no questions in the chat. I just thought, Shane, I'd give you the opportunity if you think there's anything else that you'd like carers to know or anything else you might want to elaborate on if you've got the time.
Certainly got the time. I mean, that's to deal with lasting powers of attorney. Of course, the other topic that I tend to move on to is wills. So obviously, most people know what a will is. It's where you pass on your worldly goods, your possessions at the date of your death to your beneficiaries, and you must appoint people as your executors to carry out those wishes. It seems that, unfortunately, less than half of people in the UK actually have a will. So there's a lot of people out there who leave it essentially to the state to deal with the division of their assets. And so if you die without a will, you die what is called intestate, which means that the rules of intestacy would dictate who benefits. Now, it's normally, first of all to a spouse and then to children, etc., etc. However, in the circumstances that we tend to deal with in the here, we're looking at cared for, and those cared for individuals might not be able to manage their own finances. And if they were in receipt of those sums of money that you would pass to them automatically under these rules of intestacy, then it might take them off the benefits that they have on, and they might not be able to look after the finances. They may be vulnerable in some way, and there might be people out there who'd be more than happy to have them spend their money on them. So one way that you can deal with that is if you make a will, you can put all of your funds into a trust within that will. So you'd appoint trustees, people that you know and trust, to look after the funds, and they are then the gatekeepers. So if your cared for person needs something to be paid for, they can go along to the trustees, and those trustees can say yes or no, or can deal with making payments on behalf of that person. So wills are very powerful documents. Again, probably a good idea to get some quality advice on them. And of course, wills can do anything that you want them to do, but you may not know what's the best outcome for you or for your cared for ones. Perhaps again, I'd suggest that going along to a solicitor is probably a good idea. So wills are very powerful. Get them done if you can, please.
How much does a will typically cost?
Lisa, that is not a question that you can ask one lawyer. You'd have to ask 100 lawyers and you'd probably get 100 different answers to that. What I would say though, so somebody said in one of the meetings that we had, that you can you can get somebody online for 50 quid to get it done. Well, good for you if you can, but I don't think anybody really wants a cheap lawyer. You want somebody who can advise you, who's going to take the time to advise you, to look into your circumstances, to work out what the best phrases, the best way to deal with things, including a trust and those sorts of things within your will should be. And of course, you don't know what you don't know. So if you go into something for 50 quid and you say, I want to do this, well, that's absolutely fine. You can do it, but it may not actually be in your best interest or indeed in those that you're trying to benefit in the future, their best interests. So I can't tell you what everybody costs, but I would suggest, take quality advice.
So it's not like power of attorney where there was, if you were on benefits, you could get a reduced fee or anything like that.
No,
Like with power of attorney.
I mean, as far as wills are concerned, if you're going to use a professional, then they will charge a fee. There is a will week, I think, once a year that some firms are involved in, where charities will ask for a charitable donation within the will, and they will then provide for that to be done for free. So yeah, ask around, see who's available and who can do what. But as I say, it's always better to see a professional to make sure that the advice you get and the will that is finally crafted does exactly what you need it to do.
And I think the only other question that we had was, are there any main bits of terminology or jargon that you can bust for us around power of attorney or wills?
I'm not sure. I mean, as I said, with regard to powers of attorney, the supporting guidance is really very well done. The documents themselves have a lot of guidance on them. So as far as, the term perhaps capacity, what is capacity? Actually, within the guidance, it says mental capacity means the ability to make a specific decision at the time it needs to be made. A person with mental capacity has to at least have a general understanding of the decision they need to make, why they need to make it, any information relevant to that decision, and what is likely to happen when they make it. And they should be able to communicate their decision through speech, signs, gestures, or in other ways. So again, that's a very beautiful definition, I think, of what capacity is. It goes on to say how you could assess that mental capacity, etc., etc. So there's lots of guidance in the documents, and they're very beautifully written. As far as wills are concerned, well, again, unfortunately, we've been making wills for thousands of years. There is a fair amount of terminology, but if you ask any solicitor, to put it in the plainest English that they possibly can, they certainly will. We want people to understand we haven't done our job right if you go away not understanding the document that's been created based upon your wishes.
Okay,
Okay,
great,
great.
Shane. I've just had a few more questions come through.
Great.
So the first one is the fee for the LPA application per application, as there seems to be two forms, a health one and a financial one. So is it together for the fee or separate?
It's separate for the fee. It's £92 for each document. So there are two documents, as your questioner quite rightly says, and it would be £92 for each one. But again, as Michael has suggested, if you're passported or on a low income, then that will be reduced for each one.
Thank you for clarifying. And then another question, with wills, who keeps hold of it? What's your advice? Is it registered somewhere within the government office?
Well, that's an ongoing discussion within my profession. So there are a couple of registers that you can register your will with, and that can be a good idea. I think if your executors don't know that they have been appointed, then yes, it's probably a good idea. But it's probably best to let everybody know that they are appointed, to tell those executors where the will is held, be that either at home or in your solicitor's office. We hold lots of people's wills in our offices in fireproof boxes. So there's no one size fits all answer to that. You can register centrally. There's a fee for so doing, and there are a couple of online places to do it. Or you can leave it with your solicitor who's drafted it, or you can keep it at home. But I think the most important thing is that make sure your executors know where they're looking for the document.
Great, thank you.
Great, thanks very much for that. So if there's no more questions or comments, so thank you very much, Shane, for that. And we'll move on to the third discussion, which is welfare benefits. So I'd like to invite